Hi, I'm Dave Kappos, and you are listening to IP Fridays. Welcome. I'm the former director of the U.S. Patent and Trademark Office, the former chief IP lawyer for IBM, and now partner at the New York law firm Cravath, Swaine & Moore. And I'm really pleased to be on the program.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzanne and I are welcoming you to episode 143 of IP Fridays. Today's interview guest is David Kappos, and we talk about patent eligibility, the recent moves of the EUIPO into the field of patents, and we also address some arguments of patent critics. But before we jump into the interview, I have news for you. The European Patent Office has launched a new statistics tool, a dashboard for patents with a unitary effect. And in this dashboard, it's very helpful. You can see the status of registrations. So, for example, there are 7,190 registered unitary effects in this dashboard. And you can see the fields of technology, and you can see the procedural language and the translation language. So it's really helpful to get a better understanding what patents have a unitary effect under the new UPC regime and what patents don't. Lu Pengqi, the Deputy Commissioner of the China National Intellectual Property Administration, SNIPA, has met with Shuichi Koyama, the president of the AIPPI, and they discussed about the new advances in IP in China. And Shuichi Koyama also introduced the new World Congress in Istanbul. As you might have seen, Elon Musk has renamed Twitter to X, and not very surprisingly, the new company runs into trademark issues. There are numerous earlier trademarks that are registered with the character X. So let's see how this will work out. Panasonic has launched the first major standard essential patents campaign at the Unified Patent Court against Oppo and Xiaomi. So now let's jump into the interview with David Kappos. Today's guest is Dave Kappos. If you don't know Dave, he has been the director of the USPTO and currently is partner at Cravath, Swaine & Moore. He also has been the chief IP lawyer of IBM. Thank you, Dave, for being on the show.
Yeah, hi, Rolf. Great to be here.
So I thought about talking about a lot of different topics that are currently on your mind and also on my mind. Let's start with the most interesting one that I think is the most new and interesting development. The EUIPO now thinks about taking care of some patent issues and some patent topics. Can you explain what they have in mind and what your opinion is about this?
Yeah, thanks, Rolf. Yeah, it is indeed very controversial. So the EUIPO, of course, is Europe's trademark granting authority. It's not a patent granting authority up till now anyway. For decades, since its institution, it's been a trademark granting authority located in Alicante, Spain. And they do a great job in the trademark area, by the way. And then a few months ago, the Commission in Brussels leaked a document and then eventually published it and opened a comment period, leaked this proposal again and published it that would engraft into the EUIPO a new standard essential patent rate setting mandate and adjudicatory body that would be responsible for assessing royalty rates for standard essential patents. And Rolf, a couple things going on here. One, the EUIPO just last year, its leader had made an emphatic statement saying the EUIPO has no patent competence. And so it's quite ironic to have a proposal from policymakers in Brussels to put a huge patent mission onto an agency that itself declared it has no patent competence. But set that aside, because obviously things can change, and with enough investment, you can build up patent competence over time. What really concerns me about this proposal is that it really amounts to government interference, and I'm not sure that's even a strong enough word, into a marketplace that frankly is working just fine. And Europe, particularly Germany, but Europe in general, has been the bright light for the world, the standard setter for determining and advancing balanced policies regarding standard essential patents and the licensing of SEPs. Policies that balance the interests of the implementers, which are trying to make products, and that's great, and the innovators, which are trying to make new innovations and go from 3G to 4G to 5G and the next to 6G, and that's great too, and we need them both to succeed. And so to have a marketplace that's actually working quite well, and then to have regulators come in and say, we're just going to take this over, it's crazy. It's crazy. And then you could ask another question, which is, well, why is an American concerned about this? Isn't this like a European thing? And I think that's always a fair question. And personally, I'm always very reluctant to express views about what's going on the other side of the Atlantic or the other side of the Pacific, frankly. And I honestly sometimes bristle when people from other parts of the world express views about what the U.S. should do. I find myself saying, well, thank you, but why don't you just figure out what you want to do and we'll figure out what we want to do. But this is not so simple. This is actually a global issue. It's not just a U.S. issue. And that's why the Secretary of Commerce here in the U.S. very quickly, and I think almost uncharacteristically for this administration, which has been very cautious on IP issues, came out and quickly said, this is crazy. What are you doing? Well, you guys are hurting European interests, but you are also hurting U.S. interests, and you are damaging the global innovation ecosystem. Stop it, right? And so that's where, we all feel, coming from this side of the Atlantic, if this were just a European issue, we'd be unhappy about it, but we bite our tongue and let others do what they want to do. But this is not just a European issue. This is a global issue, and it's setting policy, and it's sending messages that are very damaging to a vibrant and healthy innovation ecosystem that balances all interests. So that's, Rolf, a bit of a long answer, but I felt like I needed to kind of explain what's going on with this proposal, because a lot of people don't understand it, don't even know about it.
I don't understand it as well. And why do you think the EU made this move? What was the reasoning behind this? What do you think? You are more into the politics behind this than I am. So
yeah, that's a great question, Rolf. And without going into people's personal agendas for advancement of their careers and things like that, which gets way too personal for me to get into. What I can say is that the original leaked proposal, and then even the officially introduced one, has a series of findings in it at the beginning that attempt to answer your question, that describe a problem that requires a solution. The problem is with the description of the problem, it's false. It cites absolutely no evidence to back up its statement that there is a problem. The basic statement of the problem is to say that relationships and licensing between SEP licensors and licensees doesn't work, it's broken, and it's hurting SMEs. The problem is that's false. And and there's no evidence cited for it. And the reason there's no evidence cited for it is that it is in fact false. And there's been a whole raft of criticism that's come out. I helped put together a study and a report that came out before this. It was like last year, if I remember right, or maybe very early this year, that used a data set to measure the number of lawsuits. Is it just the U? I think it might be just the U.S. I forget if it's the U.S. and Europe. It doesn't try and get all of them worldwide, but the sort of the primary jurisdictions. It's at least the U.S. and I forget if we were able to get European data also. I think it's just the U.S. by the way. So what it did was measure the number of SEP-related lawsuits going back for like 20 years or so, and what it found is that the numbers are actually quite small. Normally, any given year, it might be 1 or 2 or even 0. There have been a few years where there have been spikes to around 10 or a dozen or something like that. And it turns out that those spikes are very, very idiosyncratic. In fact, doing this from memory, but in each of the 2 spikes that I recall, about half of the lawsuits were attributable to one company, Apple, one company, right? So if you take that idiosyncratic nature away, it turns out that the number of lawsuits involving SEPs is really small. Again, many years you don't even need 3 fingers to count them, and in other years, you need at most, a couple of hands. And this is all suits, all parties combined. So we concluded from that data that, by the way, the numbers have been trending down in the last decade. So we concluded from that data, there isn't a problem. The marketplace is actually working great. There are literally thousands of SEP licenses being signed, and to have just a few disputes, some years no disputes that go into court, it's noise level. You can't characterize this as being some kind of endemic problem with the system. And so that was one of the things that surprised me, Rolf, coming back to your question, what problem are they trying to solve? When the statement of the problem is flatly false, you've got to right away get all your antenna up saying something's really wrong here, something really strange is going on. And that is the case here. There is no problem to be solved. This is all made up. And the commission needs to receive a message, particularly from people in Europe, your side of the Atlantic, to say, this is crazy. You need to stop this and move on and solve real problems, because you're going to do real damage to the European and global innovation ecosystem. And you're sending really bad messages to countries in other parts of the world who would very much like to see royalty rates for SEPs go down, 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 which means depriving innovators of the capital to reinvest, which means there won't be 6G and 7G and beyond that at anywhere near the levels of innovation we've all gotten used to. And that's a really bad result.
Yes. So it's interesting. Maybe we don't really know the true reason why the EU is addressing a non-problem at the moment. But let's see how this will work out over the next months. I'm sure that also the large users of the system will address this or have already addressed this, and let's see. So you're saying you encourage the European players to really put some pressure on the EU to think over this move, basically.
Right.
One other topic that was on your mind was patent eligibility, and there have been a lot of decisions in the past, and some really standing out from the Supreme Court. And they might have caused some problems or solved problems. Maybe you want to talk about this.
Yeah, sure. Thanks, Rolf. So this is the area of what we call Section 101 or patent eligibility. And it's another area where, like in SEPs, where Europe has led and done a great job. Europe also has done a great job on managing the eligibility issue, managing it into being another non-issue, if you will, and spending the vast majority of the efforts in assessing patentability and validity of patents, focusing those efforts where they can be productively focused: inventive step, novelty, disclosure, quality, those kinds of issues. In the U.S., of course, in the last, I guess it's now 15 or so years, we've really gotten hung up and twisted into a knot on the topic of eligibility, or Section 101. And so bad that, our Court of Appeals for the Federal Circuit, which is in the U.S. the only federal appeal court that manages patent issues. So it's not like there's like 20 of these courts, there's just one. And there's 12 active judges. And as of last year, if I remember right, before some judges turned over, not one or two or three, but all 12 judges of the Federal Circuit had come out in various independent statements saying, we can't manage this situation. This law is broken. We can't handle the law that is our unique responsibility and expertise to manage, understand, and implement and apply. That's really dramatic when all 12 judges, right? And some people in the U.S. here have said, oh, well, this is just judges who have a pro-patent mandate. And the answer to that is no. I'm sorry. All 12 judges declared the law is broken. Every solicitor general since when I was in the government accounting office, major members of Congress. I haven't seen one member of Congress say the law is working great. There have been some who've avoided the issue, and those who've confronted the issue, like Senators Tillis and Coons, have come out very honestly and accurately and said, you know what, we need to admit it, this law is really broken. So then comes along Senator Tillis last year and introduces a bill to fix that law. Recently, I want to say last month, maybe it was June, Senators Tillis and Coons introduced an upgraded and improved version of the bill, and now it's called the PERA, Patent Eligibility Restoration Act. And in my assessment, we need it desperately in the U.S. It will go a long way toward aligning standards globally, because every other country in the world, whether it's the EU generally through the EPO, or Germany, the UK, the countries in Asia, all have an appropriate standard. The U.S. is the outlier here, and PERA would go a long way toward what I won't quite call it harmonization in the sense we think of that term, but in realigning global standards around eligibility. And importantly, it would fix the broken law, clarify that yes, the human genome is not eligible for patent protection. We all agree on that. And yes, purely cultural or economic inventions, people talk about things like marriage proposals, are not eligible for patent protection, no matter how clever or creative they might be. And even if they're implemented on a computer, they're still not eligible for patent protection. But other than that, other than those kinds of categories, inventions, broadly speaking, that have utility and touch on technology in some way should be eligible for patent protection. and the real heavy lifting should be done by the inventive step and obviousness and disclosure doctrines. So the legislation is getting a lot of notice here in the U.S. and I hope worldwide. I think it's very positive. Is it everyone's perfect solution? No, it's not my perfect solution. It includes lots of compromises that are aimed at addressing the legitimate interests and issues of those who are more cautious about patent protection and who want to see strong eligibility standards. So I would say it still maintains credible eligibility standards, but clarifies them dramatically, and will settle the U.S. law to a place that we can manage it again. So I hope folks look at that legislation, and I hope folks and frankly, again, this is a little bit like the last issue we talked about. Yeah, in a way, it's a U.S. issue, but it's actually not just a U.S. issue, because it affects companies everywhere, and it puts an overhang of a negative nature on invention incentives, on innovation incentives. So I hope folks in Europe and Asia will take a close look and will be supportive to those of us who are trying to fix that law.
I have a European question from a European standpoint. What I remember is that the US decisions always danced around the topic of technicity or a technical feature, or whether a technical feature or whether there must be a technical contribution to an invention, which is the core of the European eligibility ideas. Was that addressed in the recent proposal, or does that play a role, or is it somewhere hidden? What do you think?
It's a tough issue, Rolf. In the version of the legislation that Senator Tillis introduced last year, technological contribution, technology was front and center, and the word was used. And it garnered, I think, fairly a lot of criticism here in the U.S. because it's hard to define. I know folks in Europe and other places have struggled with defining what does technical mean, and it moves with time and it's constantly evolving. And so I think smartly, Senator Tillis and Senator Coons in the updated version of the legislation moved away from any overt mention of technical or technology or technological contribution. But I do feel like, you mentioned it, I forget what the word we used was, Rolf, impliedly, or under the cover, under the surface. And I do feel like the concept is imbued in the legislation under the surface by those categories that are excluded, purely economic, cultural, right? And this notion that adding an implementation on a computer, taking a cultural or economic activity and implementing it on a computer does not confer patent eligibility. I think without mentioning the word technology, the new legislation gets us to about the same place. So, again, smartly, Senators Tillis and Coons learning from the great work that's been done in Europe, but also the struggles that have occurred, and the fact your system is fundamentally somewhat different from ours, and the notion in Europe of implementing a technical effect test in the obviousness or inventive step test. It works for Europe, but we can't really implement that here in the U.S. In any neat way or any way that would be politically feasible. So we had to find a different way, and this was the way.
Yeah, and I also don't know whether it really works in Europe, because they decide on a case-by-case basis every time newly, like whether something has a technical contribution or not. So it's also difficult. You have basically a system where you have to dig through thousands of cases whether something has a technical contribution or not. Why does improving security of a system have a technical contribution and encryption, but why does something else doesn't have a technical contribution? Also, it's sometimes very difficult to understand, and it's just in a matter of memorizing all this case law or having a good database. So it's also not a perfect system at all. It's just a very different approach. I agree. So one other thing that was on my mind, but also on your mind, years back on your mind, was there was a strong movement of patent critics. Some also quite known patent critics said, well, we have to abolish the patent system. It's not working, and therefore we don't need it. So I wanted to talk with you about the arguments of these patent critics and address these arguments a little bit, as you have done for the last years also in talks and in papers. Maybe first we talk about maybe the most important argument that has been brought forward by these critics. And they say there is really no evidence that patents really increase innovation or productivity. What do you think? Like, what would be your response to these voices?
Yeah, I think, there's actually not just evidence, there's like 500 years of evidence that no other system for rewarding innovation has ever been created that comes anywhere close to the patent system at doing its job. A Stanford professor, Steve Haber, published an interesting paper a number of years ago, I want to say maybe 7-8 years ago or so, in which he surveyed a large number of economies over a period of hundreds of years. And he's like an economic historian, not an IP attorney, an economic historian at the Hoover Institute at Stanford. And so he used economic data going back literally, again, hundreds of years to throughout the existence of patent systems and measured strength of economic activity against strength of protection for invention. And what he found was there was no example in all of the data set of a country that had sustained economic performance. There was no example of a country that had sustained economic performance correlated with weak intellectual property protection. And there was also no example of a country that had weak economic performance covered with strong intellectual property protection. So to put that in the positive, in every single instance that could be found, right, over a large data set, many countries and a long period of time, strong economic performance was positively correlated with strong intellectual property protection, and weak economic performance was correlated with weak intellectual property protection. So, and that's just one study that sticks out in my mind. You can go through the economic literature, people like Zarina Khan at Bowdoin College, here in Maine, among others, have done research going back hundreds of years that shows, writ large, that strong intellectual property protection generally and strong patent protection in particular produce sustained quality of economic performance. And I'll give you one other example, Ralph, and this is going from the large data set to the n equals 1. As you mentioned at the beginning of the show, I'm here in New York City and I work, up in a skyscraper, and I'm looking out at other skyscrapers here in Manhattan. I had a meeting a while ago in one of those other skyscrapers with private equity investors in a company that manages literally billions of dollars, and they direct investments into various companies. This particular one has a big, set of investment funds that they run in growth stage companies and startups and tech investments. Think, biotech and artificial intelligence and med tech and, on and on. And, we are talking about a particularly troubled situation involving, one or more of their funds that was in trouble because of the problem with patent eligibility in the US. And this guy, big guy, right? At the end of the meeting, when we were all getting up to leave, he took me aside and kind of pressed me a bit. He didn't, assault me or anything, but he kind of pressed me and he said, "Listen to me, Sonny." He said, my job when I leave the office at the end of the day, I got to have more money for my investors than when I came into the office at the beginning of the day. And he said, if you fancy people with your intellectual property protection can give me that through strong IP that protects the innovations of startup and growth stage companies, I'm happy to invest billions of dollars in helping them grow. He said, otherwise, I'm just going to put my money in pork bellies.
Yeah, that's good. Because I always thought about how to connect innovation to economic success, and you just mentioned it. I mean, the startups who are innovative and innovative companies, they don't get funding unless they protect their innovation with patents, and that in turn will lead to the business case that, of course, then they have more money to invent even more stuff and then be more innovative and so on.
Exactly.
And also the large IP offices, they regularly publish reports that companies are more successful, economically more successful, if they protect their intellectual property. But one thing is that these patent critics say that the competitors, they can't really further develop a technology if it's patented, and therefore they are blocked from developing this technology. How do you address this argument?
Yeah, well, first of all, of course, patents are limited in duration. One of the miracles of the patent system is they expire. And once they expire, anyone can suddenly use the technology for free. This is why, in the US as well as Germany and many other countries, you've got such a vibrant generics pharmaceutical industry with the vast majority of medicines, including prescription medicines, that are insanely inexpensive thanks to the fact that patents have expired, and that exist thanks to the existence of the patent system in the first place, right? So we get both. We get this great pipeline of new medicines constantly popping, and there, I've been involved in some that have popped within the last week, and I'm sure there are many others. At the same time, we get them going generic on a very regular basis, and price competition moving in. So the first part of the answer to the question, Rolf, is, look, that's why patents expire, so that anyone can go and use the invention. The second part is, and I've been involved in this too recently, it turns out most patents can be worked around. And that's another great effect of the patent system. By forcing disclosure of the invention, the patentee has to actually, in the bargain, invite clever, creative third parties to invent around the patent and find ways to improve upon the patent that don't infringe the patent. And that happens regularly, and I've been involved in that happening recently in a case that I'm working on. And it's a great comfort of the patent system to actually work with the technical people with the patent claims of some competitor in front of you and say, okay, so how would we go about doing X, Y, and Z differently? And then actually have improved methods of doing X, Y, and Z better than what existed in the patent, and that avoid the patent.
Right.
So that's the second part of the answer. The patent system is a great tool to encourage innovation, to encourage alternative solutions to the patented problem. Then, of course, the third part of the answer that people overlook quite frequently, and I certainly knew this well when I was at IBM for many years, just take a license. You'd be amazed if you need a license to someone else's patent and you go out and ask them for a license. In the vast majority of the cases, they'll be more than happy to grant you. In fact, going back, Rolf, to the SEP issue we discussed before, over 90% of the entire patent stack that covers 4G and soon that covers 5G, over 90%, we're talking about tens of thousands of patents representing tens of billions of dollars of investment, is available from one source, Avance, a patent licensing pool, for a flat fee for installation in automobiles. So this is a very heavyweight use, $15. That's it. Less than the price to wash your car once.
Right.
less than it costs to wash your car once, the auto manufacturer gets a complete coverage under almost the entire patent stack. So that stands for the proposition, just go ask for a license. It's not that hard. And in most cases, you'll be able to get one, and it'll be very affordable.
And one thing you mentioned is that the patentees, they have to disclose their inventions at least 18 months after filing the patent. So actually, and everyone can just read all the great inventions and read about them and combine these ideas and have new ideas and be actually more innovative because they have all this information at their fingertips. And then file their own patents, and then, for example, ask the original patentees, well, do you like our new invention? You want a cross license or something, you know?
Exactly.
And yeah. Right. So it's, the arguments are not too convincing, but I wanted to address them because these were maybe the most prevalent arguments cited by patent critics. Another thing that you also briefly touched on already in your answer was that some people say that drugs are so expensive because of all the patents, and some drugs are protected by whatever 50 patents, and they can't be circumvented, and you can't work around them, and so you have to, you can't make the drug, and people die because people don't get the medication. What do you say?
Yeah. So Rolf, it's a hard problem. We all want medicines to be available to everybody. And every new medicine that gets invented, we grieve for people who need access to it and can't get access to it. And so the solution to this problem of access to medicines, it can't be tough luck. It can't be that. We've got to be better than that. But we also have to step back and ask the mature question. So what's really the root of the problem? Is it patents or is it drug pricing and bigger issues with reimbursement systems in countries, including the US as well as others? And what you find when you ask that more thoughtful question is the patent system's got nothing to do with issues with drug pricing. This is another area where I did a study and published a paper, I want to say about a year ago or so, using US government data about the healthcare spend of the US. And it's huge. And it turns out, I called it a slice of the slice of a slice problem. The name of the paper, how when you take a small slice of a pie and then you take another small slice of that small slice, you wind up with a vanishingly small number, and how that phenomenon needs to be considered here. From analyzing that U.S. government data, what I found first was that the total, and I'm doing this again from memory, so my numbers could be a little bit off, but the total amount of the U.S. healthcare spend that is attributable to branded pharmaceuticals is in the small teens kind of percentage. So it's a small slice of a multi-trillion-dollar pie. And then when you take that slice and you actually then break it down into branded pharmaceutical products that are patent protected, it's another small slice. And it turns out that when you add those two small slices up, it's somewhere around 8%, so well under 10% of the total U.S. healthcare spend is attributable to branded pharmaceuticals that are protected by patents. So from there, I observed, even if you totally wipe out the patent system, let's say you just say, we're going to wipe this patent system out totally, no more patents at all. You've not even made a dent right, because there's still the manufacturing costs and the distribution costs and all that. I mean, you've maybe chopped a few percent off of the U.S. healthcare spend. And what does it cost you? There would be absolutely no innovation, right? People say, well, maybe the NIH can fill the gap. The NIH's spend on healthcare, the National Institutes for Health here in the US, is a small, tiny fraction of what it takes to bring a product to market. So you look at that data, and then you look at one other piece of data, which is the OECD's list of the top 300 medicines in the world. Last I looked at that, there was a study a number of years ago, and again, I'm doing this from memory, so I may not be exactly right, but my strong recollection is that of the top 300 drugs treating, every major ailment you can imagine, and then something like 13 of them were patent protected. So it's like a tiny percentage. Again, these are rounding error levels that are attributable to patents. And then when you step back and ask the question, what would happen to the innovation pipeline, and would new drugs get announced, get created, and the $1 billion or more that it costs to bring them to market, would that get spent absent a patent system? The answer emphatically is no. So you wind up concluding that, to the contrary of concerns about patents blocking patient access, the patent system is likely the most significant cause and contributor to people having access to new drugs over a period of time. And again, remember, the patents expire and then generics come in. One other thing, Rolf, you mentioned in your question, people concerned that some drugs are protected by 50 patents or so. So I think you're referring, without mentioning it, to a data set and a number of studies that have been published by a group called IMAC, the Association for Medical something or other. Those studies and that data have been roundly criticized, including by members of the U.S. Senate, who have called for much more transparency from IMAC. From what I know about the IMAC data, it's just false. It includes things like patents that have expired, patents that were never granted and were abandoned, the patent portfolio globally. So you could take a drug that's got one patent in Germany and one patent in the US, but it's been patented in 100 countries, and they would count that, some huge number of patents for it. So as far as I'm aware, the data from IMAC isn't just suspect, it's false. And it's very unfortunate because it's misleading, and it's misleading policymakers into making really bad decisions. This is why members of the Senate have sent letters calling on the Patent Office to study and assess the veracity, right, of the IMAC data. And I believe those studies are going on, but nothing's come of it yet. I believe when all is said and done, we'll learn, as the particular drug makers have come out with data, loudly protesting when IMAC has identified supposedly specific drugs that have huge numbers of patents. The drug makers themselves have come out and said, this is crazy. You could look in the Orange Book, and what you'll see is we've got 2, 3, 4 patents. That's it. That's our patent estate. That's all very transparent. These guys are making things up. And so I think, stepping back then, Rolf, you can always find what I call an N = 1, some instance of someone doing something that didn't work out or turned out to be dumb or was a mistake or whatever, or maybe even dishonest. Bad things happen very, very occasionally. But when you look across the system in the life sciences area, what you find is that access to medicines is a challenge, but it's got nothing to do with the patent system. That the patent system causes, but it just doesn't just incent, it causes, it enables the enormous investments required to make new products and get them to market. And the miraculous events that we've had over the last several years, including the COVID vaccine and the follow-on treatments, not to mention, other, eye-popping innovations, curing macular degeneration and cancers, and people who, are on basically a death sentence, who can be saved through these amazing innovations. That's all to the credit of the patent system, and we ought to be celebrating the system and not decrying it for its achievements.
Right, and what comes to my mind is also that there's one instrument that can be used by governments if they see there's an epidemic and that there needs to be access to patented medicine. They can issue a compulsory license to certain patents, and sometimes that happens in some countries, and that's also a tool that governments can use. So I think what you said is completely right, and underlines the most important arguments against the arguments of the patent critics in this for this topic of the high-priced medicine and the drug patents. But this is also a tool that governments can use, of course. Two other things that I wanted to address, if it's possible, because we are running out of time, I see. But maybe you have a brief assessment about these two questions. One thing that is often cited by patent critics is that most of the counterfeit goods, they come from China, and you can't enforce patents in China. And one other thing is that patents are too expensive, and it's too expensive to enforce them. So what do you say?
Yeah, so on the China part, look, before the pandemic, I spent a lot of time in China, still follow the system there closely, and have for a long time. Patent enforcement in China has gotten to be quite good. In the large majority of cases, it's fast, it's inexpensive. The courts tend to do a good job on the large majority of cases. So for those who are of the view that the patent system is weak in China, I think you need to update your understanding of that and actually look at the data and trends in the last, say 5 to 7 years. So China patent system much better than it was in the past. Relative to your second question. So go back, give me that question again. I want to make sure I've got it exactly.
Yeah, some people say the patent system is too expensive. It's too expensive to get patents and especially to enforce patents.
Yeah. Well, look, so Rolf, patents are expensive. For hundreds of years, they've been called the sport of kings. I didn't make that term up. I don't necessarily love it, but it is what it is. It's like many things in life that are just expensive, and there's a limited amount we can do about that. What I will say is that new approaches have been helpful, including the Unified Patent Court in Europe that was inaugurated recently there, that I think will provide new avenues and more cost-effective ways to enforce patents. You've got additionally more of a focus on pro bono access to patent protection, both in the U.S. And internationally through a program that WIPO administers, the International IAP, International Patent Pro Bono Program, that is up and running in a number of countries and expanding all the time to provide pro bono, so free access to patent protection for people who don't have adequate economic means. And then the other thing I'd mention is there's a whole, industry that's developed really globally that, essentially brings venture funding to the patent world that gets patentees and inventors access to economic resources if they've got strong inventions and strong patents. So there are more options now than there ever were before. There's invention-backed financing is becoming more available, certainly in the U.S. I'm even hearing about it in India, in addition to other countries. So there are a lot of specialized vehicles available now that, for someone who's got a great invention, can help bring capital to it. Capital to protect the invention, capital to develop the invention, capital eventually to defend the invention.
So thank you very much for your time. This has been a very long interview, but quite interesting, and a lot of interesting thoughts have been presented. So thank you very much for being on IP Fridays.
Yeah, my pleasure, Rolf. Thanks for the great questions and the fun discussion.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.